My name is John Garahy and I am both a solicitor and a historian. Our subject today is the Incorporated Law Society of Ireland 1922 to 1923. The photograph on the slide is the photograph of the four courts taken in July 1922, still smouldering following the bombardment on the 30th of June 1922. The photograph is from the T.J. Byrne collection of the Office of Public Works. The building at the front of the slide on the left hand side is the Public Records Office, which contains 6 centuries of Irish history which was destroyed. Our intention is to use a thematic approach. Firstly, we will look at attorneys and solicitors from the Norman invasion to the Revolutionary period. Secondly, the Law Society and Home Rule, Partition, the War of Independence and the Civil War. Thirdly, an exploration of 100 Civil War apprentices. Fourthly, a close look at 2 such apprentices, Jack Halpen from Cavan and Dorothy Hearn from Belfast. And finally, we will look at the summation. Our approach is going to be borrowed from 1066 and all that. It will not necessarily be light-hearted, but it will be quick. This slide shows the marriage of Strongbow and Aoife in a painting by Daniel McAleese, which hangs in the National Gallery of Ireland and which we will discuss in a few moments. Time memorial appears to be an appropriate place to start for an examination of lawyers, but it is not sufficient for our purposes. Time immemorial is legally defined as the 5th of July 1189. For lawyers, this date was fixed by the Statute of Westminster II in 1275. For historians, the 5th of July 1189 is the date of accession of Richard I, the Lionheart, to the Crown of England. In 1275, as part of the settlement of the Barons' War, 1189 was fixed as the date beyond which no title claim to lands could be made. This date is still the law in Ireland. We must go to Bannow Bay on 1st of May 1169, when Richard Fitzstephen and Maurice Prendergast with 130 archers and men-at-arms landed on the South Wexford shore. They were followed in May 1170 by Raymond le Gros and by King Henry II in July 1171 to secure the loyalty of the invaders. It is a well-known story. The deposed King of Leinster, Diarmid MacMurrough, with the permission of Henry II, invited Richard de Clare, Earl of Pembroke and Sturgar, known as Strongbow, to reinstate Diarmid to his kingdom of Leinster, promising his daughter Aoife in marriage and his lands, which was an over-promise by Diarmid, as he did not own the lands under Brehon law. McAleese's painting of the marriage of Strongbow and Aoife in the National Gallery shows the aftermath of the taking of Waterford. A closer examination sees a startled Diarmid and a harp with a Norman foot. This was a prelude as to what was to happen in the future. The Normans have been described as the most successful people of the 11th century, conquering Normandy in 911, England in 1066 and Ireland in 1169. The king was the centre of the power. Society was a pyramid with the crown at the apex. The Normans believed in force, rules and law, and they introduced the common law to Ireland. To attorn, to plead on behalf of another in court, was known in Normandy in 960. It was fortunate that Henry II had skilled attorneys, for his legal basis for the conquest of Ireland was a fraud. It was based on a forged papal bull named Laudabilitor, granted by the only English Pope, Hadrian IV, in 1155. Laudabilitor is the Latin for praiseworthy, an unworthy use of the word for what was a land grab. Laudabilitor had been proven to be a fraud, with no copy in the Vatican archives. Gerard of Wales, Geraldus Cambranus, came to see what his 2 uncles, Fitzstephen and Fitzgerald, had to offer, and wrote a polemic to Henry II entitled Expugnatio Hibernia, the Conquest of Ireland. The idiomatic meaning of expugnatio is conquest, but the literal meaning is to storm by assault, which accurately describes the Norman invasion of Ireland. Henry II held the first parliament in Ireland at Lismore in 1171 and established the Lordship of Ireland in 1177 based on conquest and the fraudulent papal bull. The photograph on the slide is that of the King's Inns on Constitution Hill in Dublin, founded by King Henry VIII in 1541 on the establishment of the Kingdom of Ireland. King Henry VIII radiated unhappiness. He was unhappy with his first wife, Catherine of Aragon, his succeeding 5 wives due to lack of heirs, and in no particular order Scotland, France, Ireland, the Pope. In Ireland in particular was a cause of concern for Henry. There was rebellion after rebellion. His solution was surrender and re-grant, changing the legal basis for landholding in Ireland. He also changed the Pope as head of the Church of England and Ireland, replacing the Pope with himself. He was also very unhappy to be mere Lord of Ireland, and in 1541 established the Kingdom of Ireland, partly because of the Kildare Rebellion. Henry VIII deployed massive force and aggression towards Ireland. His execution policy was not confined to his wives. He executed Silken Thomas and his 5 uncles at Tyburn in 1535, thus bringing to a conclusion one of the Fitzgerald dynasties from the landing at Bannow Bay in 1169, a spell of 366 years. Henry was conscious of the law. He was the lawmaker. He was the king. The Earl of Kildare was executed under the attainder of the Earl of Kildare Act 1536, which forfeited the Kildare lands and estates to the Crown. Remarkably, this act remained on the Statute Book of Ireland until 2002, when it was repealed by the Statute Repeal Act of that year. Henry VIII established the King's Inns to provide for training of skilled lawyers and barristers required to keep legal terms at the Inns of Court in London, which remained until 1885. This was part of the Anglicisation policy of Ireland by the Tudors. The Tudor plantations of Ireland provided much legal work, with the dispossessed, the never possessed, and the enduring possessed in constant litigation and conflict. The enduring time from the Tudors are King's County and Queen's County, Offaly and Laois, named for the Philip II of Spain and Queen Mary. It fell to Elizabeth I to complete the conquest of Ireland by the Tudors. This slide shows an act from King James I of England and VI of Scotland to deal with attorneys. The title indicates the high esteem in which attorneys were held. In 1607, the King's Inns were reformed with a subsidiary profession. Gentlemen of the profession emerged. The King's Inns remained the governance body for attorneys and solicitors, and deeply resented by attorneys who paid fees on admission for the erection of chambers which were never built. The 1600s were disastrous for Ireland. The century included the Catholic Confederation, the Desmond Rebellion, Cromwell, and the Boyne in 1690. The Battle of Aughrim in 1691 spelled the end of Irish native rule. The native Irish started the century with 70% of the land and concluded with 15%. An Act of 1689 prevented papists from becoming attorneys, one of the penal laws. This slide shows some key dates for the Law Society. It was the French Wars 1793 to 1815 which led to the abolition of most of the penal laws, including the admission of Catholics to the legal professions in 1793. Lawyers were prominent the United Irishmen and the 1798 rebellion. A memorial to Wolfe Tone, the brothers Shears, Bagnall Harvey and Robert Emmet was unveiled in the forecourts on the bicentenary in 1998. It did take 200 years for their acknowledgement. The modernisation of Ireland was advanced by the conclusion of the French Wars. The Commissariat for the Army was established in 1809. The Ordnance Survey mapped the country in 1824. The National School System and the Board of Works, now the Office of Public Works, were both formed in 1831. The Irish Constabulary in 1836. The tithe payments and in 1838, together with the formation of the poor law unions, which were to play such an important part in the famine. The Law Society was formed as a club in 1830 to ensure solicitors attained the status to which they were entitled. The Law Society itself was formed on the 6th of June 1841 and was granted a Royal Charter in 1852 and a supplemental Royal Charter, changing its name to the Incorporated Law Society of Ireland. You will note the period 1845 to 1852 is in as the Great Irish Famine. The Great Irish Famine is the only example of Irish exceptionalism in history. There is nothing quite like it elsewhere. Some 170 years following the famine, Ireland is still short a population of 2 million. The famine provided a lot of work for lawyers. The Encumbered Estates Act of 1849 started the transfer of titles to tenants, and the lawyers were required to ensure that this process worked properly. There was innumerable disputes and litigation, which is profitable for lawyers. This slide shows critical dates in the search for Home Rule. For Ireland, the famine had two important political outcomes: the rise of constitutional nationalism and the rise of Fenianism, wedded to the use of force of arms. The tension between the two remains. Throughout the remainder of the 19th century, the Law Society became embedded in society, a recognised body to be consulted on legal administration and essential to the operation of the courts and land law. Approximately 7 presidents of the Law Society were knighted. The Law Society members were united in their professional practice, their wish to be free from the benches of the King's Inns, but not in politics or religion. Support for Home Rule was not universal. The 1898 Solicitors Act finally gave solicitors control over their own affairs, education, regulation and admission, becoming responsible for the role of solicitors, and in 1899 built a strong room in the basement of the solicitors' buildings in the forecourts. The political division in the Law Society was a counterpart to society. 2/3 wished for Home Rule and 1/3 wished to remain in the union with Britain. The Law Society was opposed to and condemned the Easter Rising in 1916. I do not propose to deal with this in any detail, as there is a considerable historiography. One anecdote that arises from the time: solicitors took part, including William Corrigan, who was prosecuted at a field court-martial, but his death sentence was commuted due to the advocacy of the prosecuting counsel, William Evelyn Wylie. Wylie was a King's counsel and had been briefed by William Corrigan, who had sent him a cheque for 5 guineas, which was uncashed. Wylie made the point to the presiding officers that if they executed Corrigan, he, Wylie, would not receive the value of the cheque. The officers took the point and commuted Corrigan's sentence. In Partition, the Law Society were implacably opposed to the Partition of Ireland. The Law Society formed a committee in 1916 and sent the President at the time, Charles St. John Halpen, to interview Sir Edward Carson, the leader of the Unionists, and John Redmond, the leader of the Nationalists, to implore them and to insist that solicitors would remain as a united body and remain under jurisdiction of Dublin, irrespective of what was to happen. This slide contains a map from the papers of Eamon de Valera in UCD and the Franciscan Partnership. It is entitled A Graphic Presentation of the Government of Ireland Act 1920. For our purposes in considering the Law Society, the Government of Ireland Act formed the legal entity of Northern Ireland on the 3rd of May 1921, but the legal jurisdictions remained in tandem until the 1st of October 1921, and we will look at what the Law Society thought of that in the next slide. On the 8th of July 1921, the President, Charles G. Campbell, unveiled the bronze tablet in the photograph on stone designed by Oliver Shepherd, RHA, erected at the entrance to the Solicitors' Building in the forecourts to commemorate the solicitors and apprentices who died in World War I. 185 solicitors and 83 apprentices joined the British Armed Forces to fight in World War I. There There were 20 solicitors and 18 apprentices killed. In death, the distinction between solicitors and apprentices preserved, each group listed in separate columns. It had been paid for by voluntary subscription of the members of the society. His speech was touching in its simplicity, an expression of sympathy delivered in a private ceremony of family and law society members, aspirational for the future of the country, acknowledging the debt to the dead. Its aspirations were realised 3 days later with the announcement of the truce on the 11th of July 1921. The people charged with ensuring peace were those elected in the May 1921 general election without a poll, comprising 124 Sinn Féin MPs with 4 Unionists from Trinity College, Dublin. Technically, they were elected to the Parliament of Southern Ireland, but designated themselves a second Dáil Éireann to commence discussion on peace terms with the British. The War Memorial indicates the allegiance to the British cause by the solicitors and apprentice solicitors, as conscription did not apply during World War I in Ireland. Pragmatic submission, if not allegiance, by the Law Society was reflected in the minutes, with correspondence and meetings with the Lord Chancellor, the Under Secretary for Ireland, the head of the Civil Service and the Castle Government. The business conducted was routine, its transaction testimony to the acceptance by the Law Society of the authority of the Castle Government. The President, Patrick J. Brady, was nominated to the Senate of the Parliament of Southern Ireland. The Law Society faced 3 difficulties in the latter half of 1921. Firstly, the near certain partition of Ireland with the loss of the Northern Solicitors. Secondly, the Sinn Féin courts. Thirdly, allegiance to which entity whilst preserving unity. Effectively, the Government of Ireland Act 1920 provided for partition of Ireland, albeit with the aspiration of allegiance to a common crown and representation in the House of Commons for both parts. The Act was stillborn. Its proposal of Home Rule was not acceptable to the revolutionary legatees of 1916, who had proclaimed the Republic, endorsed by the First Dáil and the object of the War of Independence. Legally, the Act had fundamental and permanent effect on the court and legal systems. Osborne commented that the political convulsions in Ireland in 1916-26 affected the local legal system at 2 levels, by changing the court system and a drastic curtailment of geographic reach. It's a truism to say that the 1920 Act created the legal and political geographical Ireland that exists today. The 1st of October 1921 in literal terms marked the implementation of the Government of Ireland Act 1920, partitioning the unified judicature system, fracturing the cohesion of the all-island professions, solicitors and the bar for the first time. Solicitors or apprentices admitted prior to this date were entitled to practice in both jurisdictions. The Law Society mourned the loss of Northern solicitors for both economic and personal reasons. The Council meeting of the 5th of October 1921 simply recorded the making of the orders. The Council received the proposed charter for the Northern Law Society at the same meeting and was requested to comment, and which it declined to do so. Solicitors' work was intimately associated with the general administration of the country. In fact, in its sense, it could be described as semi-official, with Patrick J. Brady incoming President. The Law Society held close relationships with the judiciary, the civil service, court officials, and was in constant communication seeking to influence practice matters. An IRA assault in May 1921 destroyed the Custom House, resulting in the loss of centuries of records, with practical difficulties proving the payment of taxes. The Law Society proposed solutions to the revenue which were accepted in the Finance Act 1921. The Law Society remained as proxy for the Northern Ireland Law Society and had to deal with any logistical difficulties that rose caused by partition. Another fundamental issue for the Law Society was the Sinn Féin courts, created by resolution of the First Dáil on the 29th of June 1920, which in 1921 were established and functioning, providing an alternative to the British courts with consequent loss of income to solicitors. The Council meeting of the 2nd of November 1921 noted the Council, having again considered the matter, are of the opinion where interest of their clients required, solicitors should be free to appear before them in any court. The Law Society in December 1921 wished for peace, concerned regarding the resumption of war, which had impacted the country in professional and economic terms. It sought strong, settled government so that normal litigation could be resumed. This was reflected in the Council meeting on the 7th of December 1921 with Patrick J. Brady as President. It was the first meeting of the 1921-22 year. Once a new President was congratulated and the routine business determined, a motion was proposed by John O'Connell, seconded by Mr. Sheridan, regarding the desire to place on its record its satisfaction and pleasure that a long and difficult negotiation for settlement had been made. The Council member was aware that the Articles of Agreement for a treaty was signed the previous day in London, with division between the plenipotentiaries. The motion was referred to a special meeting on the 2nd of January 1922 without recorded discussion. A further agenda item noted the correspondence from the Secretary to the Honsec of the Northern Law Society. The Northern members to come to Dublin to confer on future governance of profession, or Dublin would go to Belfast. This is a recurring theme coupled with reciprocity of admission for England and Ireland, which we will discuss in greater detail later. Prior to the convening of the special meeting on the 2nd of January 1922, Doyle Eireann debated the ratification of the treaty with increasing acrimony and bitterness between the members of Sinn Fein. The issues were the signing of the Articles of Agreement without De Valera's prior approval, the creation of Dominion status, and crucially the failure to secure a republic. The first item on the Council agenda on the 2nd of January 1922 was congratulations to James Macready on the granting of his knighthood, which is risible considering the high principles in debate at Earlsfort Terrace, where the treaty debates were taking, which was the home of UCD. Sir John O'Connell was criticised for the content of his motion, which was characterised as of a political nature. In consequence, it was withdrawn and a motion on your screen was proposed. The Law Society recognised the consequent disquietude as inimical to the prosperity of the country and the legal profession. Its essence was the processing of commercial work, domestic housing and, in 1922, war-damaged claims. There was not enough work witnessed by solicitors canvassing prisoners in the Bridewell for instructions. The Law Society required a functioning government of some description to preserve solicitors' livelihoods. The Secretary was directed to send the resolution to Mr. Arthur Griffith, Mr. Eddie Duggan and Mr. Eamon De Valera and the press. The Provisional Government was formed on the 16th of January 1922 with Michael Collins as chairman. The members included 2 solicitors and 1 solicitor's apprentice, Kevin O'Higgins. The Doyle Cabinet, who remained in office, answerable to Doyle Eireann, whereas the Provisional Government was answerable to the Parliament of Southern Ireland. Confusion being increased with the overlap in personnel. In British law, the Provisional Government was incepted to transition to the creation of the Irish Free State in 12 months from the 6th of December 1921, which was required by the Anglo-Irish Treaty. Irish jurisprudence disagrees fundamentally. Hugh Kennedy, Provisional Government legal advisor, later Chief Justice, wrote on the 5th of August 1922, "The great principle upon which Doyle Eireann was founded was that all legislative, executive, administrative and judicial power had its source in and was derived from the sovereign people of Ireland." The early months of 1922 were filled with uncertainty for the country. The Royal Irish Constabulary was amid disbandment, which meant that there was no countrywide police force. The Dublin Metropolitan Police remained but were ineffective and unarmed. The Civic Guard during formation but not in operation. Law and order was in part enforced by the Sinn Féin police. These were not numerous to be effective, resulting in local law and order depending on the character of the local IRA, whether pro or anti-treaty, and the nature of the relationship between them. The Council meeting of the Law Society on the 8th of February 1922 received 3 replies from the government ministers thanking the Council for their resolution. They also received a letter from Mr. T.A. Colfer, solicitor in New Ross, claiming that having written letters on behalf of landlords to tenants, he was taken by force from his home in a motor car, detained in a disused farmhouse for a day, compelled to give a promise not to continue proceedings, asking the Council to make representations to the Provisional Government, the Council to make the case known to Mr. E.J. Duggan, Solicitor and Minister for Home Affairs. The Council meeting on the 8th of March 1922 received a report from the President that he and the Secretary had met the Minister for Home Affairs, Mr. E.J. Duggan, to discuss the kidnapping of Mr. Colfer by the Irish Republican Army, together with the issue of jurisdiction between the Provisional Government courts and the Sinn Féin courts. The Minister replied the Government would deal with it. A letter was received from Gore and Grimes solicitors enclosing a newspaper report stating a non-legal person appeared before a Sinn Féin parish court. There were 3 letters received from the next meeting on the 23rd of March 1922. The Southern Law Association wished to have the plaintiff choose courts, ones adopted by the Provisional Government or Sinn Féin courts. Naas No. 1 Rural District Council would only recognise decrees obtained in Republican courts, and difficulties in Nina with cases due to Republican courts. This is a prelude to the developing crisis with the dual court system. At the Council meetings on the 24th of May 1922 and the 12th of July 1922, the text is on the screen. On the 14th of April 1922, Rory O'Connor and anti-treaty IRA forces occupied the 4 courts. This meant that there was no access to the building, and in particular there was no access to the Law Society records. The then Secretary of the Society, W.G. Wakely, went 3 times to see O'Connor, and eventually he succeeded in getting some books, including the minutes, which I am now quoting from. Following the destruction of the 4 courts on the 30th of June, the Law Society decided to put 2 claims into Dublin Corporation for 300,000 and a similar claim to the Provisional Government. The apprentices north and south were impacted by the Civil War. Their subjects were curtailed, their studies had difficulties with practical consequences as to location of lectures and exams. The Law Society leased the hall in the Royal College of Surgeons, where they were there until 1931. The reference to the military operations on the 4th of July referred to in the Council minutes was the part of the Battle of Dublin, which commenced on the 28th of June 1922, which Dorney estimates cost at least 85 lives. The Royal College of Surgeons in St Stephen's Green was located within 2 miles of the O'Connell Street, where the most severe engagements occurred. Following the capture of the 4 courts, the 25 apprentices who attended displayed a tenacity and a willingness to carry on. Fortitude was not confined to the Law Society. Trinity College Dublin, located adjacent to the fighting, held commencements on the same day. The Provisional Government on the 25th of July 1922 revoked the decree of the first Doyle dated 29th of June 1920, establishing the Doyle courts. This was the only decree of the first Doyle to be revoked. The Provisional Government regarded the Doyle courts as inimical to its success in the Civil War. There was real anger witnessed by a draft letter from Hugh Kennedy, law advisor to the acting chairman Cosgrave, analysing the basis on which action might be taken against Common, the Council for Plunkett and the Judge Crowley, and the nature of the Republican courts or unlawful societies. The Pact Election on the 16th of June 1922 provided electoral approval for the pro-treaty forces and the Labour Party, though this is contested in the historiography. The progress of the Civil War is absent from the Council minutes of the Law Society, since the Society observed the law terms during the long vacation of August to mid-October. Arthur Griffith died on the 12th of August 1922 and Michael Collins on the 22nd of August 1922, the latter killed in an ambush at Bale-na-Blow in Cork. These deaths led to significant policy changes by the Provisional Government, which prosecuted the war without inhibitions of Collins and his wish to reconcile with the anti-treaty side. The Law Society was intimately involved in the administration and organisation of the court sittings, reflected in the minutes with the appointment of the Society to the Judicial Commission in October 1922. This marked the advent of the new district courts with the appointment of 14 district justices, 7 of whom were solicitors. The Law Society was requested to nominate a member for the Senate of the Irish Free State and met the law officer to discuss the claim for the destroyed premises. P.J. Brady, the president at the half-yearly meeting, opined the courts were carried on at the request of the Provisional Government, and it would be strange and anomaly to have the court sitting and the solicitors refusing to cooperate. Richard Mulcahy, Minister for Defence, introduced the Public Safety Order on 27th of September 1922, proposing military tribunals with the power to impose capital punishment. The passage of the order was opposed by Tom Johnson, leader of the Labour Party, contending the handling of power of life or death or internment to the army amounted to a military dictatorship. The vote in the Doyle was 41 to 18 in favour. This order/act was unlawful and unconstitutional. Its passage was by a body of the Parliament of Southern Ireland or the Third Doyle, neither of which had legislative capacity. The Third Doyle was the Constituent Assembly to enact the Constitution of the Irish Free State. Dorney provides one of the best summary answers to this complex jurisprudential question, namely that the Public Safety Order 1922 does not exist in the corpus of Irish legislation. This is one of the many issues addressed by the Indemnity Act 1923, granting retrospective indemnification to all actors in the exercise of unlawful acts. The Law Society is silent on the passage of this legislation. The Council meeting on the 6th of December 1922 considered a letter from Mr. Sean O'Huig, solicitor, who complained that he was unable to interview clients in military custody. The response: to seek a meeting with the Minister for Defence, Mulcahy. The succeeding Council meeting was on the 13th of December 1922, and in the 7 days that elapsed, the Irish Free State was incepted on the 6th of December 1922. On the following day, the 7th of December, Brigadier Sean Hales, pro-treaty TD, was assassinated. On the 8th of December 1922, in Mountjoy Jail, Rory O'Connor, Liam Mellows, Richard Barrett and Joe McKelvey of the Four Courts Garrison, who were in custody since the 30th of June 1922, were executed as reprisals. The Council meeting of the Law Society on the 13th of December 1922 made no reference to any of the killings the previous week. 5 members of the Northern Law Society were appointed as extraordinary members of Council, and 7 members to the Judiciary Committee appointed by the Free State to design a new system. The Minister for Defence did reply on the position of Mr. O'Huig that a statement in writing should be sent rather than a deputation. He enclosed regulations on interviewing prisoners. 1923 is a continuation in implementation of the policy of executions by the Free State Government, extrajudicial killings, incarceration without trial, suppression and defeat of the anti-treaty forces. The anti-treaty forces conducted acts of extreme violence, murder and intimidation, with sectarian overtones in Cork with the killing of Protestants and class and sectarian in the burning of the houses of the senators and the law officers. The murder of Dr. O'Higgins, father of the Minister for Home Affairs, Cavan O'Higgins, was noted in the minutes. We've seen that the Law Society had close relations with the 3 governments who exercised power, fulfilling advisory and practical roles such as the Judiciary Committee. The Judiciary was transformed by retirement or transfer to Northern Ireland. Only 2 of the previous judges remained. The relationship of the Law Society inured whether with the Lord Chancellor 1921, the Lord Chief Justice 1922 or Chief Justice 1924. The Law Society did not offer any criticism of government actions. The executions of the Four Courts 4 is indefensible in law, correctly characterised as reprisals. Neither is there overt criticism of anti-treaty actions, saving expressions of sympathy to family members of victims. Mrs. O'Huig wrote to say her husband was arrested on the 2nd of March 1923, now in jail with no charge preferred, asking for assistance from the Council, who decided to write to the Minister for Defence asking for information to enable the Council to reply. The Law Society was compliant to authority, irrespective of the composition of the authority, thus the permission for solicitors to appear before the Shin Fein courts. With the demise of these courts, the official courts received support. The failure to support Sean O'Huig whilst Halpern tried without trial or to make any representation indicates an unwillingness to confront or challenge government in protection of its own members. The Council meeting of the 25th of April 1923 noted a letter from Mr. J. A. Long, Assistant Solicitor to Mr. O'Huig, asking the Council again to take steps to have him brought to trial. The order of the Council was to write to the Minister. Matters improved for Mr O'Huig. He was the first chairman of Aer Lingus and president of the Law Society in 1947-8. The convergence of the arguments of the Law Society was both authoritarian and submissive was found in the enactment of the Solicitors Ireland Act 1898, Amendment Act 1923. The Law Society enlisted the support of Lord Glenavy, Chairman of the Senate and former Lord Chancellor. It was introduced as a private member's bill in the Doyle by Mr Fitzgibbon KC, who was brief in proposing its merits. It has been explained to the Doyle twice within the week, and I do not wish to inflict any more oratory on you. The bill comprised two sections. The second, a citation. Section 1A provided for the substitution of the word twice for thrice in relation to the holding of annual examinations, and Section 1B for reciprocal admission of solicitors from England and law agents from Scotland. The bill was adopted as a government measure and passed without a vote. The prosaic analysis the Law Society increased revenue whilst reducing costs by eliminating one series of examinations. The fundamental object to ensure parity with the UK. It was also evidence of the close relationship of the government with the Law Society. We now turn to examine the 100 Civil War apprentices who sat the examinations of the Incorporated Law Society in the period from May 1922 to May 1923. The 100 on a percentage basis are shown on the slide. 48% were from Leinster, 23% from Ulster, 19% from Munster and 10% from Connacht. This chart shows the sample of the solicitors by religion. There were 15% from the Church of Ireland, Congregationalist 5%, Presbyterian 10% and Roman Catholic 70%. This almost accords exactly with the figures in the 1926 census. This slide shows the dispersion of the apprentices on a numerical basis throughout Ireland. As might be expected, the preponderance of solicitors come from the east coast of Ireland, including the largest population centres of Dublin and Belfast. This slide is also unique in that it shows the last solicitors entitled to practice in both jurisdictions prior to the implementation of the Partition of Ireland. The legal jurisdiction was partitioned on the 1st of October 1921, but the Law Society in Dublin in October 1922, almost 1 year later, decided to allow any solicitor who was apprenticed prior to the 1st of October 1921 to finish under Dublin. The Law Society of Northern Ireland commenced operations in July 1922, but its Foundation Act was not passed until December 1922, and in the interim period due to the lacuna, the Law Society in Dublin decided that apprentices could finish in Dublin. The Law Society of Northern Ireland accepted this. The slide is also interesting because it shows the disposition throughout the country. What the slide does not show was that religion of each apprentice, which we have discussed earlier. Religion was not the notable factor in gaining entry to the profession, though only one of the apprentices that was under consideration was not apprenticed to a co-religionist. The religious affiliation mattered in career advancement, and with 18% of all the professional classes were Protestant, the percentage in the legal profession extending to 36%. The research has shown the critical path to enter the solicitor's profession was familial or wealth in the absence of familial connection. This is true in all cases, that if you did not have a family connection, you required wealth to enter the profession. There was one exception, which was law clerks. The solicitor's profession is unique in enabling people with vocational experience to enter the profession without requiring any educational attainments at either second or third level. The genesis lies with the formation of the profession and its long struggle to escape from the overweening authority of the King's Inns. The practice of vocational entry was a response to the dichotomy between both branches of the profession, with court advocacy and judgeships reserved to barristers, the carriage of transactions vested in solicitors. Once free, the Law Society and the legislature combined to create an entry mechanism to include vocationalism. This slide provide you with the opportunity to answer the questions arising at the preliminary examination in May 1920 of the Incorporated Law Society of Ireland. Question 1 in English history. Mention any risings of the barons from the reign of Henry II to the end of the reign of Henry IV. Geography. Question 1. What are the causes of currents in the ocean? Give a description. English literature. What external evidence exists for determining the date of As You Like It? What is meant by the sources from which Shakespeare derived material for his plays? The other papers were Euclid, arithmetic, algebra and Latin. It was possible to apply for a modified examination, with some law clerks exempted from taking Latin, indicative of the lack of formal education. The intermediate and final examinations comprised legal subjects. The most common method of entry to the profession at the time was being successful in the preliminary examination. There were graduates, but they were not numerous, and it was possible also to do a foundation legal course in the universities, which allowed entry. We come now to the star of the show, Jack Halpen from Cavan. The photograph on your screen is courtesy of Jacqueline Maloney and shows the sitting of the last county court in Cavan in 1922. Jack Halpen is third from the left at the back. Although born in Dublin on the 14th of August 1899, John Ralph Jack Halpen was a scion of a County Cavan dynasty. The draft pedigree of the Halpen of County Cavan was prepared in 1705, and the records of the family solicitor's firm Allen and Halpen, dating from 1692, are held in the Public Record Office. John Halpen's great-grandfather, Nicholas John Halpen, was born in Portarlington and was a distinguished student in Trinity College, graduating in 1815. Nicholas John bequeathed his scholarship and attachment to the Protestant interest in Trinity College to his sons, including William Henry, who was admitted to the role of solicitors in Trinity Law Term 1886. Jack Halpen inherited the scholarship and ability equal to his forebears, and he was the fourth generation of his family to attend Trinity College in Dublin. The marriage certificate of his parents, William Henry and Caroline Isabella Hutton, shows his parents resident in Cavan and Swanland Bar, in which Church of Ireland parish the marriage was solemnised on the 4th of September 1898. William was a partner in Allen and Halpen solicitors, who acted as solicitors to the great estate landlords, including the aristocratic Humphreys, Farnham and Headford estates. The drumbeat of Jack Halpen's childhood was the Irish aspiration for Home Rule. The Irish question had bedeviled British politics since 1886, when Gladstone had introduced the first Home Rule Bill, which caused a seismic shift in and between the political parties in Britain. The Irish Times on the 30th of December 1893 noted Mr. W.H. Halpen of West Cavan Registration Association was elected to serve on the Council of the Irish Unionist Alliance for 1894. The third Home Rule Bill, enacted as the Government of Ireland Act 1914, provided for the exclusion of certain of the Ulster counties. Jack Halpen was educated at the Church of Ireland boarding school of Mr. Alan Carey at Mourne Park in County Down. He then attended rugby school. The rugby school newspaper reported on a debate held on the 24th of February 1917 that the Allies, having proclaimed the rights of small nations, it is the duty of the government at once to remedy the grievances of Ireland. The report noted that Mr. J.R. Halpen opposed the motion and made yet another violent onslaught on the unhappy Irish priests. The words Ulster of course excluded provided a concise summary of the Ulster question. The Unionist aspiration conforming to the territory capable of Protestant governance. Halpen's soon-to-be professional body, the Incorporated Law Society of Ireland, was implacably opposed to the Partition of Ireland. Jack followed the generational path to Trinity College in 1918, reading for arts and law degrees. He became indentured as an apprentice solicitor to his father on the 28th of February 1919. He was the star law student. He was first in feudal law and civil law in Trinity, and he was also first in the solicitors' examinations. During his time at Trinity, he was a member of the officer corps and aspired to unionist politicians. On completion of his studies, he was admitted as a solicitor in 1923, and he was the beneficiary of what we have already noted earlier about the Law Society. The Law Society in Dublin performed a final act against partition, and in consequence, Jack Halpen was entitled to practice in both Northern Ireland and in the Irish Free State. His time in Dublin was fraught with danger. He was there throughout the Civil War. We've already seen that the preliminary examinations held on the 4th of July 1922 took place during the Battle for Dublin. Jack Halpen was one of the people who attended. He did face the difficulty as to what might happen following partition. The year 1922 had an end-of-century feel for solicitors. Partition created two legal jurisdictions, with Cavan on the contiguous fault line between both, a source of national grievance and practical complications because of the land border. The Doyle courts were abolished by decree on the 25th of July 1922, and a choice was now have to be faced by all solicitors. It was Halpen's choice to stay in Cavan. At first there did not appear to be any change, but change there was. The county court and magistrates were abolished, replaced by circuit, district courts and the Court of Criminal Appeal. In our photograph, Judge Brown and the solicitors of Cavan posed to capture the last sitting of the county court, cognizant of the demise of the ancient court system. The fact was that the solicitors, not Judge Brown, attended the same courthouse the following week, applying the same laws, in the main adjudicated on by a judge appointed by an Irish government for the first time. The change was both prosaic and fundamental. The harp replaced the crown. Doyle has described the period 1922-1939 as a history of disappointment, referencing the insularity of the Irish Free State with its emergence as a Roman Catholic state. In the main, the Protestant population withdrew from politics, although Cavan was one exception. John J. Cole, Grand Master of the County Cavan Orange Order, was elected as an independent TD from 1922 to 1932 and again in 1937 to 38. Protestants remained significant actors in that there was enough Protestant clients to support Allen and Halpen solicitors' practice. Kevin O'Higgins, Minister for Home Affairs, stated in the Doyle in January 1923 that solicitors and barristers are, as a class, a nervous body unsuited to the robust times in which we live. The Halpens proved to be robust. Their practice continued, representing their current clients and also their clients of yore. The Irish Times on the 4th of April 1926 reported on the court applications of Captain Richard Maxwell for destructions of mansions at Arlia and Fortlands on the shores of Lough Sheelin in a series of raids between September 1922 and February 1923. Mr. K.C. Dockrell appeared instructed by Messrs. Allen and Halpen solicitors Cavan. Maxwell is the family name of the Baron's farm of Farnham. Dolan, in her conclusion, posited that the examination of the Irish Free State as living in the shadow of its revolution underestimates the intensity of the bread and butter politics from the outset. The Halpens excelled at bread and butter politics. Jack Halpen became interested in legal politics and was elected to the Council of the Law Society in 1949 and became president of the Society in 1957 or 1958-59. It was a time of concern for the Law Society and country. The 1950s witnessed emigration on an aggravated scale. The census of 1961 represented the native population of the Republic of Ireland at 2.815 million. The number of solicitors had declined to 2,122, dropping to 1,349 in 1971, comparable to 1922. Halpen was explicit in his warning that the profession was overmanned. It should be taken into very careful consideration by the parents of any boy or girl to be apprenticed unless there is an opening available in a family firm. His presidency of the Law Society gave witness to his reconciliation to Republican rule and to the extinguishers of British rule in 26 countries. One of the people in the photograph is shown O'Huig, who was in prison in March 1923 when Jack Halpen was admitted to the role. O'Huig was incarcerated without charge or trial by the Free State government in November 1923. Jack Halpen married Eleanor Hamilton in the First Presbyterian Church, Holywood, County Down, in 1957, the year prior to his presidency of the Law Society. He continued to reside in Cavan, where his practice continued. He retired in 1962. It is very easy to determine that the Halpens were beneficiaries of the conquest and plantation of Ireland, and in particular Cavan. Following partition, Protestants in Cavan still asserted an Ulster Protestant identity. Halpen's younger self in Rugby School opposed Home Rule while his tenure in Trinity, and a commission the Irish Fusiliers were markers of his loyalty to the Crown. His obituary in the Anglo-Celt affirmed that he was a staunch member of the Church of Ireland and was for many years president of the well-known Cavan Lawn Tennis Club. Those admitted usually only Protestant and professional people. The probate value of his estate was £90,414, 28 in value £1,528,000, placing him among the wealthy elite. The obvious finding is that he was a colonial legatee, but that is to miss the life choice afforded to him by the Law Society and the Partition of Ireland. He could practice north or south. He chose to practice in south. Jack Halpen was one of the left behinds, unionist trapped in a republican state, mirroring the nationalists in Northern Ireland. He was first and foremost a Cavan man, part of the community. The speakers at the first Cavan Gun Club dinner on the 5th of March 1949 included Father P.J. Gargan, Jack Halpen, Father Charles Travers, St. Patrick's College and George Maloney Sr. His identity became one of choice and affirmation, retaining his heritage while changing his allegiance to Ireland. His obituary further noted he was one of the leading social, cultural and business persons in Cavan town. He died in 1970. This slide shows a photograph from the Belfast Telegraph on the 3rd of February 1923, celebrating the admission of Mary Dorothea Hearn as a solicitor. In point of fact, the photograph relates to her passing her final examination. Hearn became the first woman solicitor in Ireland. She came from a Presbyterian family which was settled in County Down for centuries and who were wedded to education. Her father was the county surveyor for County Down, and her mother was the daughter of a solicitor, Arthur Jameson, in Dublin. Her grandfather was James Hearn, was the professor of moral theology at Assemblies College in Belfast and moderator of the Presbyterian Church in Ireland in 1901. Hearn was an excellent student. She attended Victoria College and then to Queen's University, where she read for the degrees of BA and LLB. In consequence of her degrees, she only sat one examination in the Incorporated Law Society, and that examination was in January 1923, which she passed, becoming second to Jack Halpen from Cavan. Her achievement was made possible by the Sex Disqualification Act of 1919. Part of the women's suffragette movement was to increase women's franchise, but also their civil rights. Women had been excluded from being members of the legal profession, and may I recommend that you read what are referred to as the persons cases in relation to the attempt by women to enter the legal profession. The courts in no jurisdiction helped women. Hearn became the first woman because the Sex Disqualification Removal Act of 1919 became law on the 23rd of December 1919. Hearn became apprenticed to her uncle T.M. Hearn in Belfast the following February and completed her studies in the Law Society in 1923. On her admission as a solicitor, she practiced with her uncle T.M. Hearn until 1946. Eireann was a modest, unself-assuming woman. She was constant in her devotion to her family, and for this reason her practice life suffered. Her parents died young, and she acted as a guardian to her younger children. She was quietly pleased to be the first woman admitted as a solicitor in Ireland. Her celebration. This slide shows the advance of women in the Irish Free State and the Republic of Ireland as solicitors. In the Irish Free State there were only 2 women solicitors in 1925, 9 in 1930, 44 in 1950, 62 in 1960, 359 in 1980, with a substantial increase to 2,141 in 2000. Women are now the majority gender practicing solicitors in 2019/20, with 6,232 women and 5,730 men. Women became the majority gender in 2017, which the Law Society says, to its knowledge, it is the first time a female majority has existed in any legal profession in the world. The photograph comprises the Irish reports on the law stacks in Berkeley Library, Trinity College, Dublin, taken by me. The photograph is a visual reinforcement to the argument of the status quo ante. 1921 IR represents British government, 1922 IR the Provisional Government, 1923 IR the Free State Government. The accessibility of the Law Society archives has allowed a rounded view of an institution that in 1922-23 survived 3 governments, British, Provisional and Free State, the loss of 30% of its members and the destruction of its buildings. The research discloses that the Law Society forged close relations with powerful actors on a pragmatic basis. It did not criticise the exercise of unlawful acts. Additionally, the identity of the first women to be admitted and practice as solicitors was clarified. The Law Society's vigorous and sustained opposition to partition and its attempts to retain jurisdiction over northern solicitors was noted. There was profound regret at the fracturing of the jurisdiction in place for centuries. The close connections with governments of all descriptions emphasised its pragmatism and submission to the current authority. The use of the word country by the Law Society is remarkable. The word is used 13 times in direct quotations from Law Society officers or in speeches. The expression pro patria sua for its country was known to the Law Society members. The use of the word country in expression of Ireland as a unified entity, recalling its antiquity, its place as a nation. The argument that the Law Society was submissive to authority remains, with the caveat that such submission was to the country to whose prosperity it was wedded. This concludes our talk, and again may I wish to thank Cavan Library Service and you for listening today. Thank you.